Hi and welcome to today's webinar, the Amendments to Queensland's Associations and Corporations Act. My name is Carly Hanson and I'm a Sector Sustainability Coordinator here at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, they're the Turrbal and the Yagara people. I wish to pay respect to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islander people continue to play in our society. As today's webinar is being viewed by people throughout Queensland, I'd also like to pay respect to the traditional owners of the land throughout the state and extend a warm welcome to any First Australians listening in today. We're delighted to welcome Sonia Byers to present today's webinar. Sonia is Principal of the independent consultancy Governance by Design, and she'll be talking to us about the recently introduced changes to Queensland's Associations Incorporation Act, noting that the amendments were passed by Queensland's Parliament just last week, so our timing has actually ended up spot on. Some of the changes to the Act, such as offences for insolvent trading, have the potential to significantly impact on the governance of community organisations. So Sonia has kindly agreed to give us an overview of these amendments, as well as an analysis of the potential real-world impact on the governance of incorporated associations in Queensland. I'll let Sonia tell you a little bit more about herself when I hand over in a moment. But first, I'll just let you know that today's webinar is being recorded and we'll pop that recording on our website later today or tomorrow, together with the PowerPoints. They'll all be emailed out to everyone who registered as well. There are two ways you can ask questions. So you can press the button that looks like a hand. We'll see that hand come up at our end and we'll unmute you so you can ask your question via the microphone if you have one, or the easier method, you can just type your question into the question box on the control panel and we'll read that question out for you. We'll hold all the questions over to the end of the presentation, but feel free to type them in as you think of them. Sonia will also be running some polls today, so please make sure you put your answers in when they appear on the screen. I'll now hand over to Sonia and talk to you again at the end of the presentation. Thanks, Sonia.
We're delighted to have the opportunity to speak with you. And as Carly said, we've had legislation recently pass and in a very timely way for today's discussion. And in fact, the legislation received royal assent yesterday. So you'll see on that first slide that we've got the amendments to the Associations Incorporation Act, and it is now the legislation has passed. So we are going to start the session with a poll just to seek some feedback from you all so that we can ensure that the content meets the expectations of you as an audience.
Okay, I'll just get that poll up. Okay, you should see that poll on the screen now. So if you can just pop your answers into the poll, I'll read the question out for you. So has your management committee discussed migrating to a company limited by guarantee? Yes, no, or you're already a company limited by guarantee. So I'll just, those responses are coming through. So I'll just give you a couple more moments to put your vote in now, and then I'll close it down. And apologies also for, it sounds like there were a few sound issues at the beginning when I was doing my intro, but if you do have any problems as we go through, we'll sort that out for you. But just while you're filling in those answers, if you do have any questions, please pop them into the chat box and we'll respond to those at the end of the session. And I'll now close the poll. Thank you. Okay, so I'll just share those responses with you. So Sonia, it looks like 26% say yes, they're already thinking about that, 60% no, and 14% are already a CLG. So I'll just hide that now and you can transfer back to the PowerPoints.
Thank you all. So having regard to that, the legislation that has passed, we are going to talk through that in the lens of what is the most appropriate structure for your organisation and what is the impact that some of the requirements that will now be set out for incorporated associations, what might that have on your current governance architecture and some proposed changes that you'll need to think through if you wish to stay an incorporated association. So for those who may have attended any of my sessions in the past, this slide might be quite familiar to you. I'm particularly interested in the neuroscience of decision making and particularly governance. And this slide tells us when you change the way that you look at things, the things you look at change. We're constantly in a changing environment. COVID is a primary example of that. And here we have some fresh legislation which asks us to perhaps change the way that we've looked at things. We may have had a suitable structure in the past, and maybe it's now timely for us to consider if that's relevant for our organisation's success into the future. So as we're talking through this today, I'd encourage you to think about things through the lens of changing the way that you think about things. So what will we cover today? So we've got some amendments that we want to talk about to your primary legislation for those of you who are structured as incorporated associations, and then also relevant to incorporated associations, the Taxation Administration Act requirements, which also need to you need to satisfy before the end of this year. That's applicable for charitable organisations. So the amendment bill was introduced on 26 November. It was adopted on 16 June 2020, and as I say, it received royal assent yesterday. So the introduction to the bill stated the intent for which Parliament was looking to organisations to improve their process or to essentially mirror what is already common law. So the government has suggested in the introduction to the bill that it's committed to supporting the work of incorporated associations and assisting them to operate more effectively. These amendments will ensure that there is no longer duplicated annual reporting for those of you who are structured as incorporated associations and you're also registered with the ACNC. So that is one case that we see will provide some really good administrative back-end improvement, that there will no longer be an obligation to report through to the Office of Fair Trading as well as the ACNC. So that does remove some unnecessary duplication and reduce some red tape. The bill also proposes a number of amendments aimed at reducing the burden experienced by incorporated associations. And we're going to talk about whether or not that in fact has been achieved. So there are some sense of some of the amendments that there actually might be a higher level of expectation for performance, and we'll make sure that we cover those as we go through. So they're described as basic governance principles, the duties that management committee members owe when sitting on the board or management committee of an incorporated association. That's how the government's framed them up, as basic governance principles. Those basic governance principles have always been in some legislation across Australia entrenched. However, in the Queensland legislation, they have not been set out. And so we've taken the role and expectations for performance of management committee members from the common law. And the most recent case law which talks around that is Pine River's training organisation. And in that case, which is a couple of years old now, the court was asked to consider if a management committee member was a fiduciary and owed duties akin to that of a director of a company. And essentially in that case, the management committee member was seeking to obtain information to enable them to carry out their responsibilities. And so the court was asked about their role and the relationship and their responsibilities. And in that case, it was held that the role of a management committee member is akin to that of a fiduciary of a director of a company. Now what we have is legislation, because it now is entrenched after royal assent, that now tells us and introduces duties so that officers need to exercise their powers and discharge their duties with care, skill and diligence and act in good faith. So, in addition, the management committee members must not improperly use their position or use information. These are the common law tenements and expectations for the minimum standard of care and diligence expected of directors and now management committee members, and also the second bullet point, which is misuse position or information, is the minimum standard of behaviour expected. So this mirrors the common law, but it's now entrenched in legislation. This new The new provision, which is the duty to prevent the association from trading whilst insolvent, does increase, or perhaps it now tells management committee members what their expectations are around financial literacy. So it is now expected that management committee members will turn their mind to ensure that an organisation does not trade whilst insolvent. In addition to that, there's now going to be a statutory obligation to disclose any material personal interests. So where there is a material or personal interest, that needs to be disclosed at the meeting of the management committee. So what do those best practice governance principles look like in practice? Well, under the legislation as it's currently drafted, I've recently looked at this from the context of an incorporated association having recently established a subsidiary entity. We know that not-for-profit organisations can earn income for profit-making entities, and this incorporated association has done that. It's established a subsidiary, and interestingly, that subsidiary is a public company limited by guarantee. And so we were considering whether or not the management committee members sitting up on the incorporated association had any exposure to the activities being carried out by the subsidiary entity. And to my knowledge, and without having a court determine this, there is no protection under the now new legislation that provides protection with respect to subsidiary entities for the holding company being the incorporated association. In addition to that, one of the other major differences between these new changes to the Act and the Corporations Act for those entities who are established as companies limited by guarantee is that there is no safe harbour provided. So this is now going to be one of the key delineators between the two governance architectures. As an incorporated association, management committee members will not have the benefit of safe harbour. However, that is provided under the Corporations Act for directors of companies. In addition to that, duties will not be switched off under the ACNC legislation for incorporated associations. So again, a company limited by guarantee, as a director under that legislation, you owe the governance standards under the ACNC Act, but not the duties under the Corporations Act, although it's out of scope for today's discussion, but there's some very clever academic lawyers that I have the privilege of sitting around a table with who would argue that, but we'll put that aside. The duties are not switched off under the Associations and Corporations Act. So there will be a balance and an understanding around how you cover your duties under both pieces of legislation. Now, you might say, well, they are essentially the same duties. Unfortunately, when the ACNC legislation was adopted, they didn't adopt the general principles of language which we normally see in duties. So there is a slight differentiator in the duties that will be owed the management committee members under both pieces of legislation. So we're starting to see some changes here at this point around the differences between an incorporated association and a company. The incorporated associations legislation has always been intended to provide a structure for small member-based organisations which have at their heart the community and are grassroots organisations. And some of the changes that have been proposed and are now adopted within this legislation are intended to essentially put a governance frame around how those smaller organisations intend and have to deal with members for better transparency and accountability. And the question needs to be asked as to whether or not some of those changes are appropriate given the size and structure and the business that your organisations might carry on. So another key difference is that the Act for the incorporated associations now requires the disclosure of remuneration for all management committee members and senior staff. Now, the draft regulations suggest this will be a lump sum, but that requires further engagement, and the consultation will occur around this point. So there is opportunity for your sector to engage. However, it's an interesting change because as a company limited by guarantee, there is no need to disclose that. Some companies may do that, perhaps in their annual reports or through their disclosure to the ACNC, but this is now going to be mandated that the remuneration for management committee members and senior staff will be disclosed to members. Okay, so this is probably the point now. Oh, we're back to a poll. There we go. That's to break us up. I'm going to go to Carly. Here we go. What is the size of your membership?
Okay, so hopefully everyone can see that on their screen. So just pop in your response, 0 to 10 members, 10 to 20, or 20 plus. Okay, so those are all coming through. Just leave it open for a few more seconds. Everyone is very onto it and very attentive, which is great to see. Okay, I'll just do another 5 seconds. Okay, and I'm just going to close that poll up now. Thank you very much for voting, and I'll just share those results with you. So you can see we've got mostly organisations with 20 plus memberships, so around 70% of people listening today, and then around 12 at 0 to 10 and 17 at 10 to 20. So I'll close that one up. Thank you for completing that poll.
Thank you kindly. That provides a good lens to now talk through the next, what we call, significant change to the legislation, which is now going to be mandated grievance procedure. And the reason why I was interested in the size of your membership is this may be a major contributor in your decision-making process around how we will meet the mandated grievance procedures that will come into effect. In terms of the royal assent and what's coming through immediately, you'll be pleased to hear that this is not one of those matters that will be implemented immediately. In fact, it's subject to proclamation, but it's expected to commence by 30 June 2022. So there is going to be significant consultation around this. There is going to be a mandated grievance procedure which will require appointment of a mediator. No opt-out is permitted underneath your rules, and no disciplinary action can be taken against a member where the member has instituted a grievance procedure. The basis behind this is the Parliament was looking to ensure that a member had an opportunity to bring forward a matter which would be considered in an appropriate way without having to go all the way to the Supreme Court of Queensland to be heard. So this mandated grievance procedure will be a process that a member can commence even in circumstances where the member feels aggrieved and they haven't received a response that they're comfortable with. So to compare this mandated grievance procedure with a company limited by guarantee, a company limited by guarantee can choose its own destiny with respect to what it can do around removal of memberships, provided that there is procedural fairness. So a company limited by guarantee's constitution is a contract at law. It's a contract between the board and the company. It's a contract between the director and the company, and it's actually a contract between the members themselves. And so as a result of that contract, provided procedural fairness can be demonstrated, upon members joining a company limited by guarantee, they agree that the grievance procedure set out in that contract will be the final decision. Here, that final decision-making process around the removal of a member will include a third-party mediator. So that is a significant change. Other matters to note, Meetings can be held via technology, and because this legislation has been considered throughout COVID, you'll be happy to hear that it's not necessary for you to make amendments to your rules for that to apply. It will no longer be necessary to require the use of a common seal. There will be simpler mergers of incorporated associations, and new search and seizure powers are actually provided under the legislation. So currently the legislation includes, as most of you would be aware, under the Associations Incorporations Act, the ability to migrate to a company limited by guarantee. That is, you can remain the same entity, but through migration you become a company. That remains, but also the legislation's been drafted so that there's also an ability for two incorporated associations to merge together. So these slides were prepared before the legislation passed on us yesterday, so you can still see the reference to bill. Now that it's received royal assent, there will be substantial consultation. That consultation will come around draft model rules. There's still some discussion to be had around what actually happens when model rules are approved and organisations have rules. Do they have to replace their rules with those model rules? What's the impact if the model rules aren't directly aligned with the expectations of the incorporated association? Are they like model rules where they are currently, where you can pull them down off the internet and you can make them your own? All of that consultation is yet to come. There's also going to be significant consultation around this grievance, this mandated grievance procedure. So there is an opportunity for your sector to contribute around what this looks like so that the reforms are and result in more effective incorporated association governance architecture rather than impose additional red tape. What's important to discuss today, however, when we're thinking about what's an appropriate governance architecture for the future, is what isn't addressed in the changes. So the Queensland Law Society Not-for-Profit Committee made a very good submission to government. Unfortunately, a lot of these matters weren't addressed in the legislation. But as a result of us as practitioners advising incorporated associations, some matters have come to our attention which fall outside the legislation. So we were seeking to get some guidance around what does this look like for organisations as they currently operate, and could we, entrench some of these things in legislation to provide some comfort. And one of those is what I described earlier, which, for example, one of my clients does. They engage in activities of trading purpose, and the Incorporations Associations Act doesn't allow an association to trade. And if that is trade, it has to be ancillary to the association's principal purpose, and it can't be substantial when compared to its other activities. So for the organisation I'm describing, its company limited by guarantee subsidiary actually generates significant profit, which returns back to the organisation so that it can deliver on its mission. But is that then generation of profit trade? And so we haven't been able to get to the bottom of that, and unfortunately that wasn't addressed. Also, the Incorporations Associations Act doesn't actually permit what we describe in company limited by guarantee world as BADs, board appointed directors. So the management committee is actually unable under the existing legislation to appoint individuals at this point in time. Rather, all management committee members must be elected rather than being appointed. In addition to that, we wanted some clarity around whether or not management committee members must also be association members. So there are incorporated associations that we advise where we have some management committee members who aren't actually members of the organisation. The Office of Fair Trading has a policy position that those persons should be members of the association. However, the Act doesn't address that, and that hasn't been considered either. We wanted some agility with respect to the signing of cheques and the increase of petty cash. If you read the legislation as it's currently drafted, it's very narrow. That goes back to the expectation that this legislation was intended for small grassroots organisations, and it's very strict on who can sign cheques and how that happens. Now, we all know in practice that means it's normally signed by one person, they're left blank, and then another person signs them, for example, and we suggested that to move with the modern world, that probably wasn't the best way for agility in organisation performance if that wasn't addressed. Staying with the financial aspects, there was also a question around whether or not incorporated associations should have the ability to keep an account with a financial institution outside Queensland. Given the technological world that we all live in, is it a reality that we should be limiting the scope of management committee holding an account outside Queensland? Again, we didn't get any guidance on that, so that means that is still limited. We wanted to look at the express delegated powers to individuals. So the bill actually provides that any manager duly appointed will be an agent of the incorporated association. So this is really capturing officer, as that term is otherwise defined for a company limited by guarantee. But there was no change to the legislation after our submission around this delegated powers piece, so that needs to be considered when you're looking at that into the future as to who might be deemed an agent of your incorporated association within your organisations. There's no clarity in the new changes around the voting rights of minors. So for those organisations that permit members who are younger than 18, do they have the capacity to vote? And interestingly, this is one that we come across all the time when making changes to constitutions for clients. Clarity as to where the election of the president and treasurer should occur. So most of the time in governance practice, the election of the president and treasurer will occur at the management committee level, and arguably there's a way that you could read the legislation which suggests that that actually should be, those two roles should be elected at the general meeting of members. And then we've again looked at this recently for a client, and we often are asked to put terms into the constitutions, rules of incorporated associations as to the term of office that can be held. Case law does provide for a greater term, more than 1 year. However, the legislation says it's 1 year. So in practice, most incorporated associations would operate under their rules, and if there's a term, they would go past that 1 year before an election was held. The clarity that's not provided under the legislation. So what's then the differentiator between an incorporated association and a company at this point? We're saying that at this point, the duties and responsibilities under the changes to the legislation escalated, that management committee members will be held to a higher account for their performance and behaviour. Unfortunately, some of the protections that are offered to those who are directors of companies limited by guarantee haven't come across. We also haven't had, through these changes, any clarification to some of the matters which in governance practice would assist us in deciding what is the most appropriate structure. So that's the changes to the Act. I'm now just going to cover the Taxation Administration Act. So for those incorporated associations who are also registered as charities, you need to ensure that your rules cover prior to 9 November that the income and property used is solely for promoting the organisation's objects. Now, it's likely that you'll have a winding up clause in there, you'll have a no distribution clause, but the Taxation Administration Act now requires that very specifically those clauses cover off these requirements prior to 9 November. No part of the income can be distributed, paid or transferred to members. And then on dissolution, the assets remaining must satisfy those requirements set out in that slide. So we're now going to go to a poll.
Okay, that poll should be open now and on your screen. So the question here is, will you now, after hearing what Sonia's mentioned, speak with your management committee about migrating to a company limited by a guarantee. So yes, no, or for those who are already a CLG, it's a bit moot. So those responses are coming through. We'll just leave it open now for another few seconds to maximise those. All right, just another 5 seconds. Okay, great. I'm just going to close that poll up. Thank you. And share it back with you. So you can see, Sonia, around half of our audience are going to have a chat about potentially migrating to a CLG, 30% still on no, and 17% already.
So then the questions that you might like to think about, which will guide some of your discussions around this, is an incorporated association the most appropriate structure for our legal service? So to that end, you'll be thinking about your members, and if your members are your management committee, for example, then perhaps that membership grievance mandated process won't have so much of an impact. If you are of a size and scale where you're currently running other businesses, you may like to think about, does that mean that you are engaged in trade which is more than ancillary to your primary purpose? If you now have a set of rules which doesn't include or reflect the expectations of the duties and responsibilities, what sort of changes do we need to make to our rules? And what are they? Does that change the way that we behave? If so, what does that look like? So, for example, you might not have a conflicts of interest policy because you haven't had to disclose or work through what managing those conflicts might look like in the past, but now you have an obligation for disclosure, so you'll also have to demonstrate how you're going to manage that. So you'll need to think through what that might look like in terms of the insolvency provisions. Are we concerned if we run on the line of just meeting our debts as and when they fall due? Are we comfortable that we've got robust processes in place so that we are not going to become individually responsible because there is no safe harbour that's provided to us if we're a company limited by guarantee? If we haven't got the changes in our rules which talk about the use of technology, and although it's not necessary to state those changes in our rules, should we update that anyway, given the learnings that we've had through COVID? So perhaps even for those of you who aren't thinking about migrating or wouldn't consider that this was a concern, you may want to consider if there's any changes or refreshments that you need to make to your rules to ensure compliance with the new legislation. In terms of the Taxation Administration Act, that is really important to look at those changes for anybody that has property in Queensland, anybody that has a stamp duty exemption, the GST. These changes must be made to ensure that you can continue to receive any tax exemptions that you currently are entitled to, because they will be looked at into the future. So then the question I'd then like to, the last piece I'd like to say is, for those of you who are registered as charities, whilst you stay an incorporated association, you now need to understand not just the ACNC Act, but also have some frame around the director responsibilities that are now set out in the legislation. So are we comfortable that we can meet both sets of obligations? And really they're very close in their wording. So if you're meeting one, you should be able to meet both. We normally say to clients who are companies limited by guarantee, try and meet the Corps Act obligations because they're slightly higher, and I'd say that about the Associations Incorporations Act because those duties reflect the common law, whereas, as I said earlier, the ACNC duties were watered down slightly with their wording. So to that end, now go to questions. Welcome questions. Thank you.
Okay, fantastic. Thank you, Sonia. There have been quite a few questions that are coming through. So just for those who want a little reminder, just type your question into the question box and we'll be able to hopefully get to as many as we can. So firstly though, Sonia, what's your feeling about the extent to which the lack of a shield for directors against the insolvency provisions will adversely affect the incorporated association sector? For example, would you be likely to see a drop-off in people willing to be appointed to boards?
This is not normally one matter that people turn their mind to a lot until they get onto the management committee. And then once they start to see that they might be running a little thin to the ground, then maybe it might become concerning. So unfortunately, we'd probably like to see a better understanding before people go on board as to what those risks look like. In saying that, it hasn't been the case that for companies, we've seen a decline of people willing to participate before safe harbour came in. So I'd like to think that it won't limit the ability to bring good people onto management committees. However, I think the difference will be that with smaller organisations who are unpaid management committee members, there may be a higher risk to them because solvency might be a bigger issue than in some of the other larger organisations. So it might deter, because once people understand that there's a personal obligation here, then that risk could outweigh the benefit from being unpaid.
Since you brought up unpaid, there are a couple of questions that come through sort of around that remuneration change. So firstly, from Faylene, in regards to the remuneration disclosure for senior staff, is senior defined anywhere in the Act?
This is what's going to be tricky. Now, all of this needs to be worked through, and part of that will be via that consultation phase. When we look at it, it uses those words, the agent of the organisation. So you would arguably, if I was to suggest what I think it will cover, which could be proved to be very wrong, I think it will cover all of the people in the executive team.
Yep. Okay. So in small organisations where there might not be an executive, it would cover probably the CEO.
Your CEO, your EO, yes, yeah. Company, your secretary, if you've got a secretary and they're paid, yes.
Right. So what will directors have to do you think, to make sure that they avoid the effect of these provisions? So, for instance, will organisations have to do more to protect directors? Would directors need to take more responsibility for their financial management skills and ability to interpret information? So that's really around that insolvency provision.
So this is the financial literacy continues to be a key question around all board tables, and often what we see in the incorporated association landscape is too heavy a reliance on the person who holds the role of open inverted commas treasurer, close inverted commas, because we know from the common law, and now it's going to be entrenched in the legislation in Queensland, all management committee members owe responsibilities with respect to financial acumen. So there won't be any basis to say, well, I'm sorry, but the treasurer was responsible for that. So I do see that there will be an education piece for those who may not come with that background and wisdom. There may need to be some extra upskilling around tables to ensure that all management committee members understand their responsibilities in that area.
Great. So what are some of the key things that organisations need to understand about the transition from the incorporated associations structure to that company limited by guarantee structure? Are there any tips or traps or pitfalls to be aware of?
So primarily that normally falls around the employment matters and the taxation matters. So the process itself is something that I work through with clients, and there's numerous people in the market who can do that, but you want to make sure that you're getting good specialty advice around protecting your employer's interests and ensuring that any changes aren't going to impact that, and then around the taxation. So you want to make sure that you can continue to take over any concessions that you might have when you're doing that migration.
Excellent, thank you. So Drew has just asked, are you saying that under the AIA that the management committee cannot fill a vacancy on the committee of its own accord?
That's what I'm suggesting the legislation says, yes, and we tried to seek some clarification around this point and it's certainly been the case with clients that I've advised. The legislation does not permit management committee appointed directors. It only allows for member elected management committee members.
Very interesting. So there are so many questions coming through, so we'll keep going through as many as we can. So Gina's asked whether a member of a management committee can also be a director of a company that provides products or services to that not-for-profit group.
So this is one of those questions that you're going to have to reflect on with that now the new mandatory disclosure of conflicts. That will amount to a conflict, but vested interests around a board table are welcomed. So a conflict amounts to a conflict arises where you have two vested interests. So you have a vested interest in the board that you sit on, which is always got to be your primary vested interest because you're looking at that organisation's success. But you can bring another vested interest to the discussions around personal or business interests that you might have. And you have a conflict when you can't bring independent judgment to a question or a matter for discussion. And so here, if I've understood your question right, you have a scenario where one of your management committee members may provide services or products or business to that management committee. There will be an inherent conflict there, and how you manage that will need to be discussed. So it may be that you can still do it, but how you manage it is what will be reviewed in terms of the responsibilities and obligations owed by that management committee member.
Deb's asked or sort of provided a bit of a scenario here. So at their organisation, they disclose in their audited statements the full salary and wages of all staff. MC members don't get any financial benefit. Will they need to show two sets of figures, one for senior staff and one for other staff, and a zero figure for the MC?
That's a really good question, and apologies, but there just isn't enough information on this yet for me to answer that, and I think I'd be guessing, so I'd prefer not to do that. This is an area to watch. There will be consultation, and rest assured that the QLS and other leading organisations in this area will be engaged in that process. So I'd like to think that we can influence what some of that disclosure looks like. So it is appropriate. It should be appropriate, because what you're doing is you're actually separating out incorporated associations from company limited by guarantee disclosure obligations.
So Sonia, will there be much of a real impact from codifying key duties for directors in the legislation? For instance, has there been a divergence from common law and the corporations law in this area that also might be repeated by legislating these provisions in the Act?
Yeah, so I would suggest, and have been saying this for some time to my incorporated association clients, that you owe the same duties, but until now, because that hasn't been legislated, there's probably been a bit of a disconnect in that understanding. So I think in entrenching that in the legislation, it now makes it clearer, and I think that now it probably sets that expectation and a deeper understanding, but the duties and the responsibilities remain the same.
And what would you say might be the possible consequences for an association that is trading if it was found not to be an ancillary activity because of the size of the profit generated by the ancillary entity? Are there penalties or any other consequences?
If for example, the incorporated association has had some taxation concessions, that would call into question that, for example. And yes, there may be some other matters which could be impacted by whether or not the incorporated association was complying with its obligations under the law. So it may run into trouble in that sense as well.
Okay. Quick one, can management committee members be paid honorariums?
Yes, well, that depends upon your rules. So if you've got the capacity to do that under your rules, it certainly isn't prohibited under the legislation at the moment. You might need to look into, again, if you've got taxation concession status, does that impact that? So I'd look at the governance architecture that you have and then check those again, those sort of matters, but there's nothing prohibiting it in this new changes.
A couple of questions have come through specifically around the impact of COVID-19. So firstly, whether there are any exemptions to the solvency liability due to COVID?
Great question, thank you. So as you know, as most of you will know, the moratorium for companies in that sense Unfortunately not. There is none of that under this legislation for incorporated associations.
And secondly, has COVID-19's impact on an organisation's capacity to fulfil or gain variations for funded contracts been considered in the amendments?
Not as far as I'm aware, no.
Another one about contracts. So Natalia's asked, what is the impact on forming contracts with incorporated associations? Should they consider contracts with directors?
Let me try and answer that if I've understood you, Natalia. So would we want to now contract with individuals rather than with the incorporated association? The individual management committee member still owes duties and responsibilities for the incorporated association's performance. So to my mind, if I've understood your question right, it would still contract with the incorporated association. And now arguably, although I would suggest otherwise, the legislation now suggests that there's a standard that you have to ensure through your duty of care, skill and diligence that that organisation performs under that contract. Now those duties have always been there at common law. Now we understand that they're in the legislation, so there might be a more heightened awareness of those duties.
Okay, great. Thank you. That answers your question, Natalia. And now just a couple from James. So does a small incorporated association need to have an auditor's report for its AGM? So for example, if it was less than $5,000 turnover a year.
I might have to take that one on notice, James. That's a question that I just can't answer from the top of my head.
No problems. And I guess this is probably something that everyone is now thinking after hearing about these changes. Sonia, will they need to amend their constitution?
Yes, look, I think you would, as a governance advisor, I'm a little bit biased from this response, so go with it. I'd always suggest that any organisation would review and refresh their rules every 3 to 5 years. When there is significant change to legislation like there is now, you would want to check and refresh that your rules at least address these matters that we've discussed today. And to the extent that you are a not-for-profit who's registered as a charity, you would certainly at least want to tick off on your taxation administration obligations.
Great. That's everything. That's all the questions. So dealt with extremely efficiently. Oh, no, I've spoken too soon. Spoken too soon, as often happens. So Drew, thank you for sending through another question. So how would you ensure that all committee members have good financial literacy, and what would you do with a member who refuses or fails to take steps to gain that literacy? And Drew's a treasurer, so I know he's all over it. But...
Oh, thanks, Drew. So this is where, again, I'm a little biased here. So part of my business is to provide governance training, and so in boardrooms, because I think you can send individuals off for really relevant training, but to form that relationship with each other and also to understand people's strengths and weaknesses. It's good to have training as a whole collective management committee. And so there are individuals that I even work with that come in and provide basic financial literacy training. And it's more directed and targeted where you need it to be. So it's your organisation focused, and it is, how do you understand a balance sheet? What does a profit and loss look like? Because that's what financial literacy is. And really remembering that our role as management committee members and directors is to ask the right question. So if nothing else, if for somebody who doesn't have that background and wisdom, if they just ask one right question, then somebody else will normally take the lead on the conversation. So I'd answer that by saying it's starting to bring forward knowledge that that person who may not have the confidence can build that confidence and identify a question to ask.
I think we've got someone from our audience who has a response for the earlier question around the financial reporting. So
you've saved me some homework.
I'll pass that over. I'll just pass that on from Patricia. I think it was to James. So Patricia said there are limits in the Act which state the financial reporting requirements of associated incorporated associations. $5,000 would not need an audit, just a financial report. So
I'm grateful for that response. Thank you for taking the time to reply.
Thanks, Patricia. Okay, so we're still ahead of time. I'm mindful that there might be another 1 or 2 questions as soon as I head towards wrap up. But Sonia, it was a great presentation and looks like some really interesting and thought-provoking changes that are coming through with these latest amendments. And certainly well-timed presentation. So thank you so much for taking the time today to come in. If anyone does have any other questions they'd like to send through, and Rebecca's just popped one into the box, I'll read that one out now. Thank you. So would you ever suggest an unincorporated association as a good idea for a medium-sized sports club?
That's a really good question. So I'm advising an unincorporated association at the moment, which is Australia's longest standing unincorporated association and one of the largest member-based organisations still in Australia. And so we are talking about what is the most appropriate incorporated structure for them to go to, because unincorporated associations are a very scary beast to belong to. There is no protection. You have no veil of incorporation, which is what a company provides, and you also have no protection under any legislation like the Incorporations Associations Act. So if you are currently structured as an unincorporated association and you're a medium-sized entity, my view is run or look to the Incorporations Associations Act legislation, which again allows you to migrate from being an unincorporated association to an incorporated association. So there's migration provisions in the legislation which allow you to come in and obtain those protections under legislation. Otherwise, you are individually responsible for all debts, contracts, etc. as an unincorporated association. There's no protection for you whatsoever.
Yeah, sounds like a bit of a scary place to be. Eek, yes, correct. And so Rebecca. All right, well, we might leave it there for everyone and to let Sonia get on her way. So thanks again for your participation today, everyone. Apologies for the sound at the beginning. I will re-record that intro and join it back into the webinar recording before we pop them up online later. We'll also pop up the PowerPoints for you to view after the session, and there will be a short survey that will pop up after this one closes down, so we'd really appreciate you taking the time to complete that for us. But on behalf of everyone listening in today, thank you so much, Sonia, for joining us. It was a great presentation and lovely to see you and hear from you again.
Thanks, Carly, and thank you to you all. Thanks for the questions and the engagement. Thank you.
Okay, see you next time.